Today, we're talking about birthright citizenship, the 14th Amendment, and one of the most important phrases in the Constitution that most Americans have heard repeated many times, but very few have ever heard explained. Subject to the jurisdiction thereof. That phrase matters. It matters because citizenship is not a small administrative benefit. Citizenship is not a library card. Citizenship is not a rewards program, it's a political membership in the U.S. It carries rights, protections, duties, inheritance, voting power, the future representation, and national identity. So when the country can't agree on who becomes a citizen at birth, we don't have a small paperwork dispute. We have a constitutional problem, a political problem, and a national sovereignty problem. The 14th Amendment was adopted after the Civil War to correct one of the greatest moral and constitutional crimes in American history, the Dred Scott decision. It was meant to make clear that Black Americans born here and owed protection here were citizens of the United States. It was meant to slam the door on the idea that a whole class of people born under American law could now be treated as permanent outsiders. That history matters. Conservatives should not run from that history. We should tell the truth about it. The 14th Amendment was necessary because the country had allowed politics, courts, and cowardice to corrupt the meaning of citizenship. But here is where we are now. More than 150 years later, Congress has allowed one sentence in that amendment to carry the entire weight of the modern immigration policy. The country has changed radically since 1868. The speed, the scale, the incentives of migration have changed. Air travel exists. Tourist visas exist. Student visas exist. Temporary workers programs exist. Illegal border crossings at modern scale exist. Birth tourism exists. Sanctuary jurisdictions exist. Entire legal industries now operate around exploiting gaps and ambiguities in the American immigration law. And Congress has done what Congress does best when courage is required. It's hidden. Congress has not passed a serious, coherent statute defining how citizenship should apply to children born to illegal aliens, temporary visa holders, tourists, diplomats, lawful permanent residents, and people who have no lawful permanent attachment to the United States. Congress has not built the record. Congress has not forced the debate. Congress has not made members take a vote. Congress has not told the American people in plain language what it believes citizenship means in the modern age. Instead, Congress has let courts, agencies, and presidents fight it out. Then everybody runs to cable news and pretends to be shocked that the courts are making policy. What did you expect? When Congress refuses to legislate, power doesn't disappear, it moves. It moves to the executive branch. It moves to bureaucrats. It moves to federal judges. It moves to advocacy groups filing lawsuits. It moves to the administrative state. And when we sit around complaining that people we elected to write laws are no longer the people actually making the rules. President Trump tried to force the issue with Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. That order took the position that children born in the U.S. should not automatically receive citizenship when the mother is unlawfully present, or when the mother is here temporarily, and when the father is neither a citizen or a lawful permanent resident. It seems really simple, doesn't it? The Federal Register confirmed that order was signed on January 20th, 2025. Now, let's be clear. I understand exactly why Trump did it. I get it. I get it. It makes sense to me. I understand the impulse. The executive branch looked at Congress and said, you people are not doing anything. So we will. That's what happens when the legislative branch becomes ornamental. A president steps in the vacuum. But the problem is that the executive order is not a constitutional amendment and is not a substitute for legislation. And we have to start understanding that. The president can enforce law. The president cannot, he can direct agencies. The president can challenge assumptions, but the president cannot, and I repeat, cannot by themselves settle the meaning of the 14th Amendment. So that's why it ended up in court. And in Trump versus Barber, the Supreme Court rejected the executive order to attempt to deny birthright citizenship to children born here to parents unlawfully or temporarily present. The court held that the children are citizens at birth under the Citizenship Clause. Now, some people are going to hear this and say, well, it's over. Court spoken. Legally, for the moment, that is where we are. But politically and constitutionally, the larger conversation is not even close to being over. Because the question remains, why was this left to an executive order in the first place? Why did Congress not do their job? And this is at the heart of what we're going to talk about today. Because not even Justice Kavanaugh, while disagreeing with the court's constitutional analysis, pointed out that the statutory question was much easier. He said the executive order went beyond what was current federal citizenship statute authorizes, and that if the order were to be lawful on statutory grounds, Congress would need to amend the law or enact new legislation. Then he said the obvious. Congress has considered bills on birthright citizenship over the last 30 years, but it's never actually passed one. And that's the line. That's the tell. Congress has considered it. Congress has talked about it. Congress has campaigned on it. Congress has sent fundraising emails about it. Congress has gone on television about it, but Congress has not passed a damn thing. So, don't tell me this is only a court problem. Don't tell me this is only a Trump problem. Don't tell me that it's only an immigration problem. Congress problem. And more specifically, it's a courage problem. Because the Constitution gives Congress enormous authority over naturalization and immigration. It gives Congress the power to write statutes, define procedures, create enforcement mechanisms, hold hearings, subpoena evidence, build a record, and place questions squarely before the judiciary. Congress cannot rewrite the 14th Amendment by ordinary statute. Let me be clear here. Congress cannot pass a law that simply says the Constitution means the opposite of what the Supreme Court held it means, okay? And expect the law to magically survive. Of course not. This is not how constitutional government works. But Congress can legislate. They can clarify federal statutes. Congress can define categories. They can make findings. They can force clean judicial tests. Congress can say, here is what we believe. Subject to the jurisdiction thereof means, in the modern context, here's the evidence, here's the historical argument, here's the policy record, here's the statutory framework, and now let the constitutional system do its work. Now, that's not radical. That's representative government. What Congress has done years ago is simple in concept, even if it's difficult in execution. It should have written a citizenship clarification statute that deals honestly with every category in the U.S. What happens when a child is born to two American citizens? Easy. Citizen. What happens when a child is born to a citizen and a non-citizen? Easy. Citizen. What happens when a child is born to lawful permanent residents who have made lawful, durable attachments to the U.S.? Congress should define that clearly. So what happens when a child is born to diplomats? We already understand that diplomat families are not treated the same way because they are not fully subject to American jurisdiction in the ordinary sense. Now, what happens when a child is born to foreign soldiers occupying American territory? Again, historically recognized exception. So what happens when the parents are tourists? What happens when they're temporary students? What happens when they are temporary workers? What happens when they are here illegally? What happens when they entered unlawfully 2 weeks before the birth? What happens when they overstayed a visa years ago? What happens when the mother came here for the specific purpose of giving birth so the child could receive American citizenship? Now, these are not imaginary questions I'm asking here. These are modern questions, and a serious country answers modern questions with serious law. Instead, no, Congress left the phrase subject to this jurisdiction thereof be interpreted through the court battles and executive improvisation. In the majority, Trump versus Barbara leaned heavily on the common law tradition in the United States versus Wong Kim Ark in the 1898 Supreme Court case that recognized birthright citizenship for a child born in the U.S. to Chinese parents who were lawfully domiciled here. The court in Barbara said that the citizenship clause incorporated the common law and granted citizenship to nearly all children born in the U.S. and subject to American power. But here's the conservative objection to that, and it's a serious one. Wong Kim Ark involved parents who were lawfully and permanently residing in the United States. It did not involve today's scale of illegal immigration. It didn't involve modern birth tourism or temporary visa categories as we know them now. It didn't involve a world where someone can board a plane, give birth, obtain citizenship for the child, and then use that status as part of a long-term immigration strategy. So when people say, well, it's been settled for 125 years, I say, settled as to what facts? Settled as to lawful residence? Mm-hmm. Because that's what Wong Kim Ark addressed. Is it settled as to diplomats? Yeah, that exception was understood. Settled as to hostile occupation? Well, yeah. Settled as to modern illegal immigration and temporary presence at scale? That's exactly the question Congress should have forced into law decades ago. Justice Kavanaugh made a point that should not be ignored. He said that the constitutional issue is not straightforward. He criticized the idea that the exception recognized in Wong Kim Ark must be treated as permanently closed, set of and frozen in 1868. He explained that constitutional principles remain constant, but their application must address modern circumstances unknown to the framers. Because originalism does not mean pretending airplanes do not exist, okay? It doesn't mean pretending modern visa systems don't exist. It doesn't mean pretending illegal immigration at a national scale doesn't exist. It means the meaning of the Constitution remained fixed, while the law applies that fixed meaning to new facts. And that's what Congress should be doing. And that's where Republicans especially need to stop playing games. Because it's not enough to just to tweet in birthright citizenship. It's not enough to go on television and pound the desk. It's not enough to clap when Trump signs an executive order and then act betrayed when the courts strike it down. Oh, what am I going to do? The Congress believes birthright citizenship has been stretched beyond the original meaning of subject to the jurisdiction thereof. Then Congress has to write the bill, hold the hearings, make the findings, take the vote, and defend the law. And yes, that means political risk. That means Democrats will call them names. It means activist groups will sue. That means that the media will run emotional stories. That means the universities will produce experts saying the matter is settled. That means that the Republicans will get nervous and start to look for exits. That means turbulence. And we've talked about turbulence in this show. So what? Because that's what governing is. We've said for a long time, governing is much harder than getting elected. And it should be. So if American people are tired of elected officials who want the applause of courage without the cost of courage, they want to be seen as fighters without actually entering the fight. They want to blame the courts for everything while refusing to give the courts a serious statute to review. They want presidents to act like emergency substitutes for congressional failure. That, my friends, is not sustainable. And it's not constitutional. And this also goes deeper than just immigration. This is about whether citizenship has meaning. If citizenship is automatic under almost every circumstance at physical birth, regardless of whether the parents have any lawful or permanent allegiance to the U.S., then Congress should say that openly and defend it. If Congress believes that citizenship requires more than physical location, then Congress should say that openly and defend that too. But this half world that we live in now is ridiculous and outrageous. The public debates on issues in slogans. The court debates in its 194-page opinions. Presidents try to move through executive orders. Agencies wait for instructions. Hospitals issue birth certificates. States process documents. Families build expectations. And Congress sits there like a bump on a pickle and a spectator in its own constitutional obligation. That has to end. The Citizenship Clause was written after a national trauma. It was written because America had failed to protect its citizenship. The people who were born here, lived here, worked here, suffered here, and were owed justice here. We should honor that history. But honoring history does not require us to surrender national sovereignty in the present. A country has a right to define its political community. A country has a right to protect the value of citizenship. A country has the right to say that the citizenship is more than a loophole created by geography and exploited by bad lawmaking. And that brings us back to Congress. Congress should pass serious citizenship clarification. Not a messaging bill, not a fundraising bill, not some sloppy 3-page press release dressed up as a law. A real statute. It should amend the Immigration and Nationality Act. It should define the relevant parental statuses. It should address lawful permanent residents, temporary visa holders, unlawful entrants, visa overstays, diplomats, foreign military personnel, the children who might otherwise be rendered stateless. It should include congressional findings on modern immigration, birth tourism, temporary presence, illegal entry, national sovereignty, administrative burdens, and the meaning of allegiance in its jurisdiction. It should create a clean implementation structure so agencies are not making it up as they go. It should be written with the expectation that it will be challenged in court. Because this is how serious lawmakers behave. And if Congress believes the Supreme Court's interpretation now forecloses statutory change, then Congress should say the next hard thing: we need a constitutional amendment. I know that that's hard. I know that that's a mountain. 2/3 of Congress, 3/4 of the states, that's not easy. But constitutional government was not designed for lazy people. If the people want to alter the constitutional rule of citizenship, then Article 5 exists for a reason. If Congress believes ordinary legislation cannot do the job after Trump versus Barbara, then stop pretending there's a magic shortcut and start making the argument to the states. But don't hide. Don't tell people that you're powerless and you simply when you just simply lack courage, when you're just simply a coward. The left understands something that Republicans often forget. The left builds institutions. The left builds records. The left files lawsuits. The left works through agencies. The left pressures courts. The left writes model bills. The left organizes around language. The left fights over definition because the left understands that the definitions become policy. Meanwhile, too many Republicans are content to just whine, complain, bitch. Well, complaining is not governing. If somehow subject to the jurisdiction thereof means full birthright citizenship for almost everyone born in America on American soil, then say so and own the consequences. If it means something narrower, connect to lawful allegiance and permanent attachment, then say so and write it into law. But stop leaving one of the most important questions in American civic life to executive orders and lawsuits. Because the American people deserve clarity. Immigrants deserve clarity. The states, the hospitals, the federal agencies deserve clarity. And most importantly, citizenship itself deserves clarity. Because citizenship is not just about who gets a passport. It's about who belongs to a political community of the United States. It's about who has claim on the country and who the country has a claim on. It's about allegiance and protection and sovereignty and identity. Congress has spent decades avoiding that responsibility. That avoidance has allowed them to create this mess. So today's message for you is simple. Stop hiding behind the courts. Stop hiding behind the president. Stop hiding behind slogans. Stop hiding behind fundraising emails. Write the law. Build the record. Take the vote. Defend the Constitution like you said you would in your oath. And if the Constitution needs to be amended, then have the courage to say that too. Because a nation cannot define citizenship, cannot defend citizenship. And a Congress that refuses to define the law should not be surprised when somebody else does it for them. Welcome to the Morning Report. Truth, courage, independence. We'll see you when we see you. Bye-bye now.